So rather than put mom in a nursing home, you decided to go with an assisted living facility. After all, they can't be as bad as nursing homes, right? Well, I'm sorry to burst your bubble, but that may not necessarily be true. I'm David Terry, a nursing home abuse and neglect lawyer here in Missouri, and I've helped families navigate through claims against nursing homes and assisted living facilities. In this video, I'll break down the key differences in how these facilities are regulated and what that means if you're considering legal action. So let's jump right in with this question. What's the difference between a nursing home and an assisted living facility? In Missouri, there are some very important differences between these two entities. They're not always treated the same, and if something goes wrong, those differences can make a big impact on any lawsuit that you might want to bring. So I'm going to break it down step by step so you know what to expect if you're considering a lawsuit against either an assisted living facility or a nursing home. First, it helps to know that in Missouri, nursing homes and assisted living facilities are licensed under different rules. Nursing homes are regulated far more strictly, especially when it comes to medical care. Assisted living facilities are meant for folks who need help with daily activities and maybe some with medication and with meals and maybe getting dressed, but they don't need 24/7 nursing care. This may sound like legal nitpicking, but it matters a lot in a lawsuit because the level of responsibility each facility type has is different. If your mom's in a nursing home, the staff's expected to provide round-the-clock medical care. But if she's in assisted living, the law doesn't expect the same medical attentiveness, and that can affect your case. So let's talk about negligence. In plain English, negligence means someone didn't do what they were supposed to do or they did something they weren't supposed to do. And as a result, someone got hurt. In nursing home lawsuits, Missouri law holds these places to what is called the standard of care. And that means the staff must act the same way a reasonable and prudent nursing home employee would act in the same or similar circumstances. And if you can prove that they didn't meet the standard of care for a nursing home, then yeah, you can sue the facility for medical negligence. In assisted living, the same question applies. Did the assisted living facility meet the standard of care? Meaning, did the staff at the assisted living facility act the same way that a reasonable and prudent assisted living employee would act in same or similar circumstances? So the question is the same, but the standard is different. The staff at an assisted living facility are typically not dealing with the same level of care and medical conditions that those at a nursing home are. They're supposed to help with daily living, not provide substantial medical care. So what the law expects from them is different. If an assisted living facility ignores a resident's basic needs, like forgetting to help with meals, medication, or fall prevention, that's still negligence. But you usually have to prove that they failed at what they're actually supposed to do, not to the level of what a nursing home is supposed to do. So yeah, you can sue both, but the legal standard you'll have to meet is a little bit different. So let's use a real-world example because this comes up a lot. So we're going to talk about falls. Now, imagine your dad falls and breaks his hip at a Missouri facility. So if this happened at a nursing home, you'd ask, did they have a fall prevention plan? Did they follow the doctor's or nurse's recommendations? Did they ignore obvious risk factors? Did they have a care plan where they set forth what they were supposed to do and they failed to do it? So the big difference isn't just what happened, but what kind of care the law expects the facility to provide. In a nursing home, the bar is higher. In an assisted living facility, the bar is a little bit lower because the care needs are lower. So here's something else you need to know. In both types of facilities, you can sue the business itself and individual employees if they were negligent. So here's how this works in Missouri for both nursing homes and assisted living. Before a lawsuit can be filed, an expert witness in the same or similar profession has to review the records and provide to the lawyer what's called a letter of merit. That letter of merit needs to identify the company's negligence and, if an individual is involved, then how that individual failed to meet the standard of care as well. If the individual is a nurse, then the letter of merit needs to be signed by an expert nurse. If the individual was the administrator at the facility, let's say, then the letter of merit needs to be signed by an expert administrator. Once the lawyer has the letter of merit, the case can be filed. And within 90 days of filing the legal case, the lawyer is required to file an affidavit of merit with the court. And this affidavit identifies the name of the expert or experts used and a brief statement of what the expert found to be wrong with the care provided. There must be a separate affidavit filed for each defendant. If 90 days passes and no affidavit of merit is filed, the defense can try to dismiss the case for failure to file a healthcare affidavit. So whether it's a nursing home or assisted living facility, you still have to prove that there was negligent conduct that caused the bad result. The level of care differences between the two types of entities comes into play when determining whether the action taken or not taken reaches the level of negligence. So no matter which facility you're dealing with, evidence is critical. In a Missouri nursing home, you'll often have detailed medical charts or medication records, care plans, and possibly even incident reports. If something goes wrong, there's usually a paper trail. Assisted living facilities don't always keep the same records. They're a little different. So to provide negligence here, you may have to rely on different things like the contract that spells out what kind of care was promised. Maybe witness statements or security camera footage, if any. Notes or emails between you and the staff, and texts or photographs. Assisted living facilities also have something similar to a nursing home care plan, and it's called an Individualized Service Plan, or an ISP. One of the bigger differences between an ISP and a care plan is that an ISP focuses less on medical care and more on personal care and preferences. So here's how an example of a nursing home care plan and an assisted living ISP differ. A nursing home care plan might say something like, Mrs. Smith is at high risk for falls due to orthostatic hypotension from lisinopril. Nursing interventions: 1. Monitor BP sitting and standing before each dose. 2. Ensure call light within reach. 3. Provide one-person assist for all transfers. 4. Bed in lowest position with a cushioned mat. 5. Toilet every 2 hours on the night shift. The goal here is 0 falls in the next 30 days. An assisted living service plan might say something like, Mrs. Smith needs assistance with bathing twice weekly, dressing daily, and walking to meals. She prefers to wake up at 8 a.m. and she likes to attend bingo on Tuesdays. Facility will provide reminders for medications and check on her twice daily. Family requests that she be helped to the bathroom when she asks for assistance. So this can make lawsuits against assisted living facilities a little trickier because you may need to dig for more evidence or use different types of proof. Now, you may wonder if there's a difference in what you can recover in a lawsuit. In both nursing homes and assisted living cases, Missouri lets you seek damages for medical bills and pain and suffering. And in some instances, the injuries can be the same at both facilities. A fall is a fall, and an assisted living resident can suffer a traumatic brain injury just as easily as a nursing home resident can. In nursing homes, the medical link is often more direct because the nursing home is doing more quote-unquote medical care than an assisted living facility is doing, or at least the nursing home should be doing that. So your lawyer needs to keep that in mind as he or she considers your legal case. So here's how an example of an assisted living fall case might look. Let's say that I represent a family whose mother fell at an assisted living facility in St. Louis County. She'd been promised help with getting to the bathroom at night, but that help wasn't happening. So rather than wet the bed, she tried to get up on her own to go to the bathroom, to save her dignity. And then one night she slips. She falls to the floor and she breaks her hip, and she's not found for nearly 10 hours. In that situation, we would look at the resident's ISP to see what the facility promised to do and look at the reality of what they did or didn't do. If they had cut staffing levels for the overnight shift, we could possibly show that they couldn't possibly meet the ISP because they didn't have enough staff. Now, that's one way we could try to hold them accountable for her injuries. There's other ways, but we can't go into all those details here. Now, if that same situation happened at a nursing home, it might have also involved nursing standards, medication reviews, or even federal regulations, opening up additional paths for the lawsuit. For both nursing homes and assisted living facilities in Missouri, you should absolutely report suspected abuse or neglect to the Missouri Department of Health and Senior Services. They can investigate and sometimes fix the problem without a lawsuit, but a legal case is usually needed if you want compensation for injuries. Now, filing a complaint is not required to bring a lawsuit, but it can help your case. State investigators in their investigation might turn up records or witness statements that you wouldn't have known about otherwise, and that would take a lawyer many more months to get because the state can go in right away. Here's one of my biggest pet peeves. It's arbitration agreements. I need you to watch out for these things. Many assisted living facilities and nursing home contracts have what they call arbitration agreements. These are clauses in the admission contract that if the resident or the responsible party signs, that forces you to resolve disputes with a private arbitrator instead of a jury. Personally, I think these things are immoral and should be outlawed, but unfortunately, that's currently not the case. Now, Missouri courts have sometimes enforced these agreements, sometimes not. There's a lot of analysis that needs to be done before a court will enforce one of these. Fortunately, the Missouri Supreme Court decided several years ago that a wrongful death case is not subject to an arbitration agreement, even if it is otherwise valid. So that's really good. But a personal injury case for a living resident, that might be held to the arbitration agreement if the agreement holds up. Now, and I want you to listen to this because it's critical. If you have a loved one going into a nursing home or an assisted living facility, or if you are signing a family member into the facility, do not agree to the arbitration agreement. Carefully review the documentation and purposefully cross that paragraph out. You can even write big no across the paragraph. If you're doing it electronically, just don't sign that paragraph. Don't check that box. Nursing homes by law cannot refuse admittance to their facility because the resident or responsible person refused arbitration. Look, if you're unsure what to do, have an attorney look over the paperwork. But whatever you do, do not sign that arbitration agreement. Okay, now let's switch gears a little bit. How much time do you have to file a lawsuit should one be filed? This is where families often get confused, and honestly, I don't blame them. In general, Missouri has a 5-year statute of limitation for injury cases, and that used to be the case for injuries at nursing home and assisted living facilities, but not anymore. 20 years ago, the Missouri legislature overhauled medical malpractice statutes, and before that overhaul, nursing homes and assisted living facilities were not included in the definition of medical providers, and therefore they benefited from the 5-year general negligence statute. However, as a result of that overhaul, they were included in the medical malpractice statute of limitations, which for injury cases is 2 years. So now, if your loved one is injured at a nursing home or an assisted living facility, it's just about impossible to argue that the statute of limitations is anything other than the 2-year medical malpractice statute of limitations. So if your loved one is seriously injured in a nursing home or an assisted living facility, you have 2 years from the date of the injury to get your case on file. For a wrongful death case, the statute of limitations is 3 years from the date of the person's death. Now, I've had people call me believing that they had 5 years to bring their legal case, and I tell them if they wait 5 years, they're likely not going to be able to pursue their legal case. My advice is always get your legal case on file just as soon as you can. There's a ton of reasons why that's good advice, and not missing the deadline to file your case is a big one. But even if you're not sure whether you have a case, call an attorney. They can help you make that decision. Look, evidence disappears fast. Staff turnover is high in these facilities. Records go missing. The longer you wait, the harder it becomes to prove what really happened. So get your case on file as soon as you possibly can. Don't wait to the last minute. So in closing, can you sue an assisted living facility the same way as a nursing home? Here's your answer. You can sue both in Missouri, but not in exactly the same way. The type of negligence, what you have to prove, the evidence you need, the possible damages, these all depend on the kind of facility involved. Nursing homes are held to a higher medical standard just because they're doing medical care more so than assisted living facilities. Assisted living facilities are judged on the basic care that they agreed to provide. The most important thing for you is to get advice early. I hope you found this video helpful. And if so, you're going to want to watch our next video. That's called How Nursing Home Elopement Happens and When It Becomes Negligence. Now that video is packed with the insider information you need to spot early warning signs and to find out exactly when the law says a facility crossed the line. So click over now. Missing that information could leave your family at risk, and I don't want that for you. So I'll see you over there.